call the matter, place the matter on record.
Noted, Judge. Live Esidimeni Inquest before the Honorable Judge Tefu with case I-001 of 2021.
Today is the 20th day of May 2022. Thank you. Mr. Pihlela.
Morning, my lady.
Good morning.
My lady, like me to proceed?
Yes.
My lady, I'm going to refer this Honorable Court to a discussion that transpired on the 17th of January 2022, when I came on record as the attorney of record for Ms. Ethel Ngube and two others. This Honorable Court gave an undertaking that all witnesses who had testified before, I will get an opportunity to cross-examine at the opportune time, should I deem it necessary that I should cross-examine those witnesses. At least that is my understanding of the undertaking that was given. Further to that undertaking, I brought an application for a postponement on the basis that I was not ready to proceed on the matter given the amount of documents that I'm supposed to go through on the record, which were some 37,000 documents and counting. The court again repeated the undertaking that I will be allowed, if I feel that any particular witness who is testifying, I am not ready to cross-examine, I would then be allowed at a later stage to cross-examine that witness, my lady. And now I've endeavored through a lot of effort to not have to call up that card by proceeding with cross-examination at every opportunity when I was presented. Now, my lady, reference has been made to Section 11 of the Inquest Act, and I submit that the interpretation that seeks to be afforded to this section is incorrect. If I may refer your ladyship to Section 11 of the Inquest Act, which deals with examination of witnesses, my lady.
Yes, continue.
My lady, Section 11(1) provides as follows. The public prosecutor or any person designated by the judicial officer who is holding or is to hold an inquest to act in his state may examine any witness giving evidence at such inquest. My lady, I'll pause here and submit that in terms of this section, the public prosecutor and a person who the court designates to act in its state may examine witnesses at an inquest. Now, Section 11(2), my lady, any person who satisfies the judicial officer that he has a substantial and peculiar interest in the issue of the inquest may personally or by counsel or attorney put such questions to a witness giving evidence at the inquest as the judicial officer may allow. Now, my lady, this section is quite clear in terms of what it allows, in terms of the powers of the court, and it speaks of a witness that is giving evidence. It does not relate to a witness who is yet to be called or a witness who is yet to be subpoenaed. For that proposition, my lady, we need to look at Section 8 of the Inquest Act. And
Yes,
this section is titled Witnesses and Evidence at Inquest. The section provides as follows. Section 8(1) provides that the judicial officer who is to hold or holds an inquest may, of his own accord, or at the request of any person who has a substantial and peculiar interest in the issue of the inquest, cause to be subpoenaed, any person to give evidence or to produce any document or thing at the inquest, provided that the said judicial officer shall, if so requested by the Attorney General within whose area of jurisdiction the inquest is to be held or is being held, cause a person or any particular person to be subpoenaed to give oral evidence in general or in respect of any particular matter at the inquest. Section 8.2, my lady, says, save as is otherwise provided in this Act, the law governing criminal trials shall mutatis mutandis apply to securing the attendance of witness at an inquest, their examination, the recording of evidence given by them, payment of allowances to them, and the production of documents or a thing. Is your ladyship still there?
Hey, Pichela, I think the judge is not there.
Okay.
Sure.
Apologies, counsel. Judge is having connectivity problems, but she's sorting it out.
Oh, duly noted, ma'am.
Thank you, counsel.
problems here. I'm back on record. Mr. Pichela, you may proceed.
Yes, Your Lordship.
That's when
please.
I was kicked off. I think you were now on section 8.
Correct, my lady.
Mm.
Did Your Ladyship capture the thrust of what I was reading with reference to section 8, or should I repeat any?
You can start from section 8. It's fine.
As Your Ladyship pleases. My lady, with reference to section 8, it is titled Witnesses and Evidence at Inquest. Now, section 8.1 provides that the judicial officer who is to hold or holds an inquest may, of his own accord, or at the request of any person who has a substantial and peculiar interest in the issue of the inquest, cause to be subpoenaed any person to give evidence or to produce any document or thing at the inquest, provided that the said judicial officer shall, if so requested by the Attorney General within whose area of jurisdiction the inquest is to be held or is being held, cause persons or any particular person to be subpoenaed to give oral evidence in general or in respect of any particular matter at the inquest. Now, section 8.2 goes to provide that, save as is otherwise provided in this Act, the laws governing criminal trials shall mutatis mutandis apply to securing the attendance of witnesses at an inquest, their examination, the recording of evidence given by them, the payment of allowances to them, and the production of documents and things. I would like to refer Your Ladyship to section 1, and that is the definition section, my lady. It defines a judicial officer as, it says judicial officer means a judge of the Supreme Court of South Africa, regional magistrate, or a magistrate. And it also defines a public prosecutor to say that it means a public prosecutor attached to the magistrate's court of the district wherein an inquest is held or is to be held under this Act. My lady, with this background in place, I wish to make the following submissions. The question that we are currently tackling, that is whether or not Dr. Mkhatshwa should be recalled. The use of the word recall, it's a bit misleading because we are not, in essence, we are not recalling him in the true sense of the word because he has not testified at the time when I was on record. We are merely extending the opportunity to myself to cross-examine Dr. Mkhatshwa. Now, Dr. Mkhatshwa was a witness who had already been subpoenaed by this court and had given evidence. And this honorable court, being mindful of the fact that an injustice might otherwise occur, because that my clients at that instance, at that time, were legally unrepresented, the court extended an undertaking to me to say that you will be allowed to cross-examine this witness. And it was on that basis, my lady, that I also allowed myself to make certain concessions when I was otherwise not ready to tackle certain matters that were on record. And I understood that since I will be given an opportunity at a later stage, then there is no harm done. I will use the time that I have, my spare time, to try and catch up with the record. My lady, at this stage, there was no condition, there was no further condition attached to the undertaking given by this court. The conditions that came after were with reference to, were done in an attempt to curtail the length of these proceedings and to facilitate cross-examination. At the time when all the legal practitioners who took the opportunity to cross-examine, when they cross-examined, those conditions were not in place, those restrictions were not in place. I did not understand your ladyship's later decision to mean that that decision will be applied retrospectively and that it will affect the undertaking that I was given. I understood it to mean that all witnesses who come from the date of that order, we will be required to give a background and an indication to this court on what basis we wish to cross-examine the witnesses. And I submit, my lady, that that is in line with section 11.2 of the
Just
inquest.
a second, Mr. Pichela, if I may ask, if I understand the crux of your argument now, are you repeating what you have said yesterday? Because yesterday when we left on the understanding that a ruling was already made by this court that you have to satisfy the court and lay the basis, right, as to why you want the two witnesses to be recalled. So now, as I understand your argument now, are you revisiting everything that you addressed the court with regard to yesterday? Because I thought when I gave you the opportunity that you were going to address the court this morning and make an application, I thought you were coming on the basis that you have to satisfy the court, right, as to why do you want these two witnesses to be recalled. But just as I'm hearing what you are saying, it appears you are taking us back while the court had already made a ruling yesterday. If you can clarify me in that regard.
As your ladyship pleases. My lady, I'm merely setting a holistic background with reference to my address to this honorable court. The first issue, my lady, is...
Continue. I don't want you to be repeating. You have what you have done already. You went into section 11, section 8, section 1. Then I want to hear your argument now, because from what you have already said so far, the way I understand your argument, whatever address that you have, submissions that you have already made, it's exactly a repetition of what you have said yesterday. And I just want to indicate that there was already a ruling, right? Without repeating what I've, right?
Yes, your ladyship pleases. My lady, the provisions of the Inquest Act
Yes.
do not make any provision. There is no provision in the Act that says I need to address the court in open court on those aspects, those two aspects. What has been allowed was that when a witness has taken the oath, whoever stands up to cross-examine would then give a brief overview of what they want to deal with, and then they would either be allowed to continue, but it doesn't happen that they were not allowed to continue. Now we are dealing with a different matter here. We are dealing with one, firstly, I have to justify the recalling of a witness, and secondly, I then have to indicate on what basis I want that witnesses to come back so I can cross-examine him. And those two issues, my lady, are not being dealt with in terms of section 11.2.
Okay.
It is only the second issue that falls under the purview of section 11.2. But with regard to the recalling of a witness, that I believe would fall under section 8. But in this instance, the sui generis nature of this application is that section 8.2 itself also is not applicable, because the witness, the right has already been given for me to cross-examine that witness, which right now is being sought to be diminished. If I would have to justify the reason why I would want that witness to be called. My lady, I was not against addressing this court in chambers on the basis of my application. And that is what the Act provides. I address the judicial officer, not the court in open sitting, so that notes can be taken and basically destroy the whole purpose of my cross-examination, my lady. I am willing to address your ladyship on this aspect in camera, and that is the point that I'm making to this honorable court, my lady.
You need to address the court in camera.
My lady, I'm saying that my address should be directed to your ladyship and your ladyship alone, not in open court. It is not for the other legal representatives to comment or to chip in or to air their opinions on this aspect.
And your reason for that, you are relying on section.
I'm relying on section 11, 2 and 8.
Oh, okay.
Both sections speak of a judicial officer. And my interpretation, contextually and purposefully, my lady, is to the fact that the judicial officer is your ladyship, as I've indicated under the definition section. It does not prescribe a procedure whereby I now have to address this court in open court and indicate to this court what I need to bring forward or why I need a particular witness.
Okay.
I'm now going to deal, my lady, with the question of a legitimate expectation or a reasonable expectation.
Mm-hmm.
The reasonable expectation that was created, my lady, at the time was that I'll be given an opportunity to cross-examine as and when the time arrives, as and when that determination is being made after having perused the record. And that was done, my lady, and to me, I accepted that undertaking on the basis that the proceedings need to go forward and I'll need to catch up with the proceedings. If it had been apparent at the time that this undertaking will then later be diluted, where I'll now have to justify at each and every turn why any witness needs to be called, then it defeats the whole purpose of giving me that undertaking, my lady. We might as well proceed on the basis that I missed the bus. I came late and therefore I missed the bus.
Continue, Mr. Pichela.
My lady, the last issue that I would like to address with this honorable court, I feel that as an officer of this court, my lady, I'm duty-bound to bring this matter to the attention of this honorable court. The court may or may not be aware of it, but it is matters that I would conveniently put under a heading of a reasonable apprehension of bias, my lady. Now, with reference to this, I'm making an impatient plea, my lady, because I feel that the manner in which the proceedings are progressing, I am not criticizing, my lady, the manner in which your ladyship has sought to conduct the proceedings. I want to make that very clear. I'm merely indicating to this honorable court an impression that is manifesting. And that impression, my lady, is that whenever the honorable court has to make a decision, it allows those that do not have an interest, a direct interest in the subject matter of this, to give their inputs on issues that should only be decided upon this court. And I'll give an example, my lady, on the issues of objections. The court would invite certain comments from specific people on record to indicate whether they support or whether they are against such objection being raised. And that, my lady, creates an apprehension that the court listens more to others than it does to those that are to certain others. It elevates others above others. And that, my lady, the problem with that is your ladyship will note that none of the legal practitioners that are participating in this inquest have taken an oath to be impartial and to be objective. They are carrying mandate from their clients, and they are here to protect the interests of their clients. Where those interests conflict with the duties that they have towards the court, they are required to find a balance. Now, when your ladyship allows somebody who has a dog in this fight to then give an opinion on things that do not involve their client or on issues that the court should rule upon, my lady, to me, it creates an apprehension that that person's opinion matters more.
What are you actually implying, Mr. Pichela?
My lady, I just
so
feel
you've got a problem as to how these proceedings are being conducted.
My lady, not so much. I wouldn't
Yes,
like to.
that's how. Just come clear. I mean, just go direct to the point so that we can understand it.
Yes, my lady. I've taken issue with the manner in which these proceedings are being conducted on those aspects.
Yes, continue.
And I raised this issue of the court.
Yes, I want to understand you because it doesn't come out clear. What are you actually saying?
My lady, I'm saying that if perhaps I stand to be corrected, my lady, I understood that in terms of that section 8.4, these proceedings are following in the same manner as any legal proceedings. Now, when an objection is raised, it is for this court to deal with that objection based on the submissions of the person objecting and the person against whom the objection has been raised, or the question against whom the question. Those two issues, my lady, are between those three parties who are getting engaged in that process. In my opinion, my lady, and my submission in this regard is that when the court allows others to also chip in, it is starting to appear, my lady, as if we are now ruling or dealing with objections on the basis of a majority rule kind of thing. It's too democratic a process, and my submission would be that only the judicial officer should deal with those type of matters. Similarly, with this application, only the judicial officer should be the one to deal with these matters.
So
the others should not participate in that process.
You are not sitting alone in this court. So you want to make an application, and then the others must just be silent and not hear what you're going to say to the court. Is that what you mean? If I may, maybe I don't catch. I don't get what you're saying.
My lady,
how does that relate to the issue of objections?
My lady, I indicated that the last issue that I'm raising, it's an observation. I'm taking this opportunity because today we don't have any witnesses to deal with. So it's an issue that I would have liked to canvass with the court. And I'm taking this opportunity, my lady, to make a plea and also to bring this issue to the attention of the court. Now, the issue that I dealt with previously is the issue with regard to these witnesses in particular, the witnesses that I would like recalled.
Yes,
And
you have dealt with the issue. Now you are on the objection.
Yes.
Yes.
I'm merely pointing out, my lady, that I'm fearful that the procedure that we are adopting is creating an apprehension of bias, and it is not in accordance with the Inquest Act. It goes beyond the Inquest Act. I'm well aware that this court has the powers to determine its own processes. I'm just not certain that that is what the legislature intended, that this court should be consulting the panel before giving a decision on any aspect. I understand that the Inquest Act provides for the court to sit with assessors and that they would then fulfill these roles, especially when inviting the inputs or opinions of people who are not inherently objective or impartial. They've got mandates and they're representing their client's interest. So they are not acting in the interest of this court alone. They're also acting in the interest of their client. Somewhere those interests might align, somewhere those interests might conflict. I was just cautioning the Honorable Court on that aspect and making an impatient plea that perhaps your ladyship, if she deems it fit or deems it meet, may relook into that. That is the only basis upon which I'm making this final submission, my lady. I'm asking the court to look at it, and I'll be in the hands of the court on whatever decision that the court will take in that regard. I'm not trying to dictate anything.
Thank you, Mr. Pitlela. Is that all from your side?
That is all, my lady.
Thank you.
As the court pleases.
Yes, can I hear from the others? There is an application before us here.
As the court pleases, my lady, if I may proceed.
Yes, you may proceed, Mr. Late.
Thank you, my lady. With all due respect to Mr. Pitlela, he did not make use of the opportunity that the court offered him yesterday to explain to this court why he wants to call the witness. The provisions of section 11(2) is very clear. He even quoted that to this court. You can ask questions that this court allows. It's of no use to refer back to what happened when these witnesses initially testified. Those testimonies and what followed showed that a lot of questioning in this court was on the wrong road. And that is why we had the meeting, and it was decided that counsel should indicate why the questions they want to ask the witness should be allowed, and that the cross-examination will be relevant. To go back to where we were, where there was a lot of time wasting, is definitely not in the interest of justice. I do not understand what is Mr. Pishlela's difficulty in indicating why the calling back of these witnesses is necessary. With all due respect, he's addressed that he wants to make it before the presiding officer, yourself, alone, does not hold water. Because it's the interest of everybody, that includes all the witnesses, as well as the so-called suspects, as well as the legal representatives, must be adhered to. We must have a chance to address the court on the relevance of the cross-examination that he wants to go into. I do not have a problem with recalling any witness that had testified where there was a clear or a possible link between his clients and the witness who had testified previously. But it is clear that these witnesses had not testified about anything that can involve his clients. I do not know why it's so difficult for him to inform the court about that. We are here as officers of this court, and to assist the court to come into a justice decision. This will also touch on his last point. He says neither of us had taken the oath to be objective. With all due respect, Mr. Pishila should go back and revisit the oath that he took when he was admitted as an attorney, was an advocate to this court. We all took an oath that we will uphold the law and that we will assist the courts in coming to a just decision. That is what we are here for. We are not merely here as to serve any specific person's interest. That is why we should know why he wants to recall these witnesses. I don't want to sound difficult, but it's just strange that he had all the time since he's starting as a counsel in this matter, had time to inform us of all the witnesses that he wants to recall. But strangely, as soon as one of his clients had to testify, now these two witnesses he wants to recall. I can't understand why he had waited until now to want to recall them. especially in view of the fact that they cannot say anything regarding any of these clients. So I submit, my ladies, that Mr. Pichela did not satisfy the reason why this application was brought, and that it should be denied.
Thank you. I see there are two hands. Where Mr. Pinar? I didn't see the second hand. Mr. Profi, Mr. Van Bergen. You'll follow each other. Mr. Pinar.
May it please the court, my lady. My lady, the first issue I deem expedient to deal with, my lady, is the suggestion, if I can call it that, and I'm saying this with due respect to my learned friend Mr. Pichela, that a perception is created of bias by the court. My lady, with all due respect and deference to your ladyship and this honourable inquest court, if such perceptions had been entertained on the basis of being real, the proper procedure would have been to launch an application for the recusal of your ladyship, my lady. The fact that that has not emanated, not even at this stage, of necessity, my lady, founds the conclusion that such perception is unsubstantiated and unfounded. Because the importance, my lady, where reliance is being placed on the issue of bias by a presiding judicial official, my lady, is not of the legal representative, but in the eye of the beholder, being his or her client or clients. And the requirement is always, my lady, and this has not been presented to your ladyship or in any manner attacked, if I may refer to it as such, that justice must not only be done, it must also be seen to be done. No criticism of that nature has been directed, my lady. So therefore my submission is, my lady, with all due respect to Mr. Pichela, that the reference to any form or degree of bias is totally unfounded and unsubstantiated. My lady, the second issue I'd like to refer to is the fact reference is made that where your ladyship is called upon to hand down a decision when an objection is raised, and that it's improper to permit or allow other counsel involved to express their opinion or make submissions with regard to an objection, can never be equated with a form of bias, my lady. we are all officers of the court, and as such called upon to be of assistance to your ladyship as the presiding judicial official of this honourable inquest court. And it's my respectful submission, my lady, that inquiring from the other officers of the court, being counsel, whether they have any comment regarding an objection that's raised, my lady, is compliance with the constitutional right of obtaining information, and which your ladyship as the court deems necessary or meet to reach an proper judicial decision or adjudicate that objection, and therefore your ladyship is required to exercise a judicial discretion at all times, my lady. I mean, this is quite clear, my lady. If I may refer to the, I should can maybe use nearly the proverb of an ancient locus classicus of Rex versus Zaki, 1945, page 505 of the appellate division, my lady, where the exercise of a judicial discretion by a presiding official is very clearly elaborated upon and defined, my lady, and it's still applicable in our law today, and it complies with the constitutional requirements which each and every judicial officer is called upon to apply at all times, my lady. And with all due respect, my lady, this issue raised by my learned friend, Mr. Pitlela, is unsubstantiated and unfounded and unwarranted, my lady, because many of the, and just a simple proof thereof, my lady, is the fact that at times where your ladyship has required comment from other counsel have come out in support of counsel raising an objection or opposing the objection raised, my lady. So without having any indication what the court's ultimate adjudication of that objection would be, my lady, but that enables your ladyship to exercise a proper judicial discretion, my lady, which is proper. My lady, this is an application to have a witness or witnesses recalled to be examined. Now, it is right, my lady, that where a party proceeds with an application to have a witness recalled, such application must be founded. The fact that a party is entitled to apply, for a witness to be recalled, my lady, is not a mere formality, merely there for the asking. It has to be founded. It must be substantial. Reasons must be furnished. Not in camera, my lady, in open court. These are proceedings that are being, if I may use the word, scrutinized also by the broader public who are entitled to follow the proceedings of this Honourable Inquest Court. There's no justification, my lady, nor is the issue raised in this regard that your ladyship should be approached in camera and not in open court, in justified, nor is it substantiated. Now, my lady, with all due respect to my learned friend, as I've indicated, it is trite that when an application is launched to have a witness recall for further examination, the party launching the application must substantiate the application. Now, my ladyship, with all due respect, what is required when in substantiating the application? Grounds must be presented to the Honourable Court, indicating why it's necessary for a witness to be recalled to be examined. Therefore, there must be an indication, at least, that the evidence to be obtained, the further evidence by further examination, will be of assistance to this Honourable Court. Ultimately, when this court is called upon to make a final adjudication. Now, that requirement has not been satisfied by Mr. Pitlela, with all due respect, Ms. Milady. A further requirement that has to be satisfied, my lady, I would submit with due respect, is that of prejudice inuring to the party wishing to recall a witness for further examination that would inure to his or her client, should such an application not be granted. That requirement has not even been touched upon by my learned friend, Mr. Pitlela. Furthermore, my lady, Mr. Pitlela made reference to Section 8 of the Inquest Act 58 of 1959 as amended. And I'm just going to quote briefly Section 8, subsection 2. And with your ladyship's permission, quote, save as is otherwise provided in this Act, the laws governing criminal trials shall mutatis mutandis apply to securing the attendance of witnesses at an inquest. My lady, now it's of the utmost importance, I respectfully submit that if we have regard to the laws governing criminal trials, which is a Criminal Procedure Act, which I respectfully submit, my lady, is also applicable. But now, in this regard, my learned friend, Mr. Pitlela, has not taken note of that fact. He referred to the subsection, but left it there, my lady, hanging in the air. Now, let's have regard to the Criminal Procedure Act in this regard, my lady, and I would submit that two sections of the Criminal Procedure Act 51 of 1977 is applicable, even in terms of subsection 2 of section 8 of the Inquest Act. And that is, firstly, section 186 of the Criminal Procedure Act, which makes provision that at any stage during criminal proceedings, a witness can be called to testify should the court deem it necessary or imperative for the proper adjudication of the matter serving before court. And in this regard, my ladyship, I'd like to refer your ladyship to the well-known, also a locus classicus of Rex versus Hepworth, 1928, Appellate Division, page 265. And I, with the court's permission, would like to quote, my lady. Although, notwithstanding the fact that this is a criminal, an inquest proceedings and an inquest court, my lady, but as section 8, subsection 2 clearly states, the rules are applicable. And I'm going to quote, my lady, a criminal trial is not a game where one side is entitled to claim the benefit of any omission or mistake made by the other side. And a judge's position in a criminal trial is not merely that of an umpire to see that the rules of the game are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. My lady, these sentiments are squarely within the ambit of proceedings in terms of an inquest, in terms of the Inquest Act as we have it today, my lady, with which your ladyship has been enjoined as the presiding judicial official. So, my lady, you, in accordance with this statement, which is strike, my lady, your ladyship is an administrator of justice, more so in inquest proceedings of this nature, keeping in mind what this Honourable Inquest Court and your ladyship is called upon to adjudicate in terms of section 16 of the Inquest Act, my lady. And if we have regard to the prescripts of section 186 of the Criminal Procedure Act, a party is not entitled merely to request the presiding judicial official recall witness X, for example. A foundation must be presented to the court, and it must be done in open court, where public at large is entitled to observe and to note how the process is proceeded with and applied, my lady. And therefore, in terms of the rules of procedure which are applicable to inquest proceedings also, my lady, your ladyship is called upon to ensure for everybody who's following the proceedings to see that justice is done, my lady. And that's not only justice towards the applicant, but also justice towards all parties involved, my ladies, and towards the public at large who are following the proceedings, my lady. My lady, for a more I may just also refer your ladyship for the sake of clarity to regarding the applicability of section and the manner in which it's applied, section 186 is a matter of Rex versus D and others. 1951, between brackets 4, fourth term, SA Law Reports, page 450, and appellate decision, my lady. My lady, if the court would just bear with me, there is a further section in the Criminal Procedure Act that is of importance, and that is section 167 of the Criminal Procedure Act, 51 of 1977 as amended. Which provides, my lady, and makes provision that a witness who has testified may be recalled and who has been cross-examined may be recalled to be cross-examined further. But then that can be done, my lady, once the court is satisfied that such additional or further cross-examination is of utmost importance for the just adjudication of the matter. Keeping that in mind, my lady, it's quite clear for the party launching an application to have a witness recalled for further cross-examination, a proper foundation must be presented to the Honourable Court. In order for the court to exercise its discretion judicially, because the court's not able to exercise a discretion judicially if no facts are placed before your ladyship justify such course of action. Lady, that's quite clear from the cases I've already referred your ladyship to. And once regarders had to these sections. So, with due respect to my learned friend, Mr. Pihlela, he specifically referred to section 8, subsection 2 of the Inquest Act, 58 of 1959, which, as amended, which makes provision for the applicability of section 167 of the Criminal Procedure Act and section 186 of the Criminal Procedure Act. And both, once reliance is placed on the provisions of section 8, subsection 2, it means the statutory requirements provided for in section 167 and 186 of the Criminal Procedure Act 51 of 1977 as amended is applicable and has to be applied with, or complied, not applied, complied with, sorry, my lady. And then the last, so my lady, regarding the legally prescribed requirements that have to be complied with, it's my respectful submission that Mr. Pitlela has dismally failed to comply therewith in this instance, my lady, in order to found his application. Then the third issue, my lady, taking note the indication that your ladyship handed down when Mr. Pitlela and others of us, myself included, my lady, became involved in this matter, be it some at a later stage than others of us. But that was not a blanket authorization, which meant if a party had become involved in this inquest at a late stage, he or she had carte blanche to require witness X, Y, or Z to be recalled as a witness for further cross-examination. And I would also with respect submit, my ladyship, that Mr. Pitlela, by his own admission, concedes this aspect, my lady. Because at no stage did he present his submissions to your ladyship on the grounds this was a fait accompli. I am now exercising that right that your ladyship had granted me of being a carte blanche right to recall a witness, be it Dr. Makachwa and Ms. Buthelezi, for further cross-examination. No, my lady. That substantiates the conclusion, my lady, with all due respect, that notwithstanding the indulgence your ladyship granted and made provision for, it still had required to be properly substantiated, my lady. It had to be founded. And in that respect, Mr. Pithlela's application falls to be dismissed, my lady, not having complied with the legal requirements when an application is launched to recall a witness. And the requirements that are trite have clearly not been complied with, my lady. So in conclusion, my ladyship, I would submit it would be proper to dismiss the application due to lack of particularity and not being properly founded as required in law. The requirement and the indulgence your ladyship granted did not amount to a mere formality, simply there for the asking. May it please the court, my lady.
Thank you very much, Mr. Pina. Can I take one question and then we break tea? Who is going to follow? There was Mr. Van Bergen. There is also Ms. Coca. I think there was Mr. Profi. Then Ms. Coca will follow Mr. Profi. Yes, Mr. van Bergen.
Thank you, my lady. I will endeavour to be brief. Most of the points I wish to raise have already been addressed by both Mr. Late and Mr. Pienaar, and I am in full agreement with what they have submitted to your ladyship. My lady, if I may try and summarise my thoughts on this matter and my submissions to your ladyship. Mr. Pihlela's application, as I understand it and as argued by him, appears to be born from, firstly, the fact that he had come on record at a late stage, and secondly, that your ladyship had indicated that witnesses may, if necessary, be recalled for cross-examination by him. And he says that created a reasonable expectation at the time that witnesses may be recalled. And it would appear, my lady, that that expectation seems to be, and I submit erroneously, based on him merely having to ask for a witness to be recalled. And I submit that is the nub of the matter, my lady, as already addressed by especially Mr. Pienaar. Mr. Pihlela seeks to have an unfettered right.
Can I request Ms. Mokgojwa not to disrupt the proceedings?
Thank
Ms.
you, Madam. I
Mokgojwa,
wanted to highlight that.
what is happening? Ms. Mokgojwa, please. Thank you.
I'm sorry, Judge. I didn't even see that my camera is off.
Thank you very much. Can we proceed?
Thank you, my lady. Mr. Pihlela appears to seek an unfettered right to recall and cross-examine witnesses who have already testified. He can never be entitled to that, my lady. He is constrained by both the provisions of Section 11(2) of the Inquest Act and by the directive that your ladyship issued. And I submit it is important that the wording of that directive be revisited, not revisited, but be placed before this court again. I refer, my lady, to the directive number 1 dated 7 February 2002. And in the first paragraph, and I will limit the address to the first paragraph, your ladyship directed as follows: this directive is aimed at expediting the process and taking into account the issue of relevance, and I emphasize that, the issue of relevance. From now on, counsel, and I wish to also emphasize from now on, counsel who wishes to cross-examine a witness will have to outline the issues he or she would like to raise during cross-examination before the commencement of cross-examination, and the court will have to screen those issues to determine whether they are relevant or not. If they are not relevant, the court will disallow that line of cross-examination. This shall apply particularly in respect of counsel whose clients are not implicated by the evidence of such a witness who will be testifying. My lady, the importance of that is your lady outlined very clearly. Cross-examination will be determined by relevance. Secondly, that directive applied to all counsel from now on, in other words, as of 7 February 2022, and that it applies particularly in respect of counsel whose clients are not implicated by the evidence of such a witness who will be testifying. My lady, the fact that Mr. Pihlela came on record at a late stage does not exempt him from the applicability of this directive. It applied, as it clearly states, from the date of the directive. And it specifies that examination of witnesses will be limited to relevance, such relevance to be demonstrated before being allowed to cross-examine. My lady, I submit that relevance pertains both to, firstly, the issues sought to be addressed in cross-examination, and then secondly, and that appears from the last sentence of the directive, by the interest of the prospective cross-examiner's client to those issues. If there is no relationship between the cross-examiner or the cross-examiner's client and the issues, then the directive will be applied more specifically. My lady, I submit, as both Mr. Late and Mr. Pienaar have done, that the application by Mr. Phihlela does not meet the requirements to enable him to have the witnesses that he seeks to recalled, in fact. My lady, turning to Mr. Phihlela's comments regarding a reasonable apprehension of bias that is entertained by him. My lady, the authorities are very clear, and the practice of dealing with such issues is very clear. If one is of the opinion that a judicial officer is biased or that there is a reasonable apprehension of bias, then a substantive application should be brought for such judicial officer's recusal. If such an application is not brought, my lady, it can only mean that there is no substance to any such apprehension that may be held. It may be a personal feeling that the representative has, Mr. Phihlela in this instance, but there is no facts upon which he can substantiate that. He sought to do so, my lady, by referring to the manner in which your ladyship dealt with objections that were raised. And I understand his argument to be that your ladyship, I want to see if I got the wording right, but that your ladyship had taken opinions from a panel. And he implied that that was a particular panel wherein your ladyship invited specific persons to provide input. My lady, that is not what factually happened, and that is not what the record will show. Your ladyship has at all times invited all representatives, all participants, to provide opinions if they deemed it necessary to do so. And that is no different than what happens in our courts every day. An objection that is raised may not apply only to the person who objects. It may also be of interest, and perhaps vitally so, to other representatives representing other clients. And for that reason, it is appropriate, my lady, that the court should invite other parties to raise whatever arguments they may have, whether for or against the objection. My lady, the record will also show that there are some counsel who have taken a more active role in these proceedings than others, and there is no reason why your ladyship should not, if your ladyship deemed it necessary, invite a person by name. if those were persons who had, throughout the proceedings, indicated that they have a bigger interest or are more interested in assisting the court. That certainly is no indication whatsoever of bias on the part of your ladyship. My lady, my concern about Mr. Pishlela raising this issue in the manner that he did is that it is improper. It smacks of an attempt to intimidate the court, and it should not be allowed. Not that I think for one moment that your ladyship will be intimidated, but it is improper to do it in the manner that it was done. My lady, as regards Mr. Pishlela's reference to the representatives not having taken an oath of impartiality, I don't want to repeat what Mr. Late had said, but my lady, I submit that throughout, many of us that have taken part have shown an impartial approach, an approach that is aimed at assisting the court to coming to the correct conclusions. And I may in that regard, purely from my own perspective, refer to my intervention, I think it was yesterday, in Dr. Talatala's cross-examination regarding any causal relationship between the plastic found in the late Deborah Peshla's stomach and the cause of death. I had no interest in Deborah Peshla as regards the involvement of my clients, but I deemed it necessary, my lady, that that issue be raised because I was of the opinion that it would assist your ladyship to come to the correct conclusion on that point. So as regards any implication or any insinuation by Mr. Pishlela that intervention by representatives is aimed purely at serving their own clients' needs, that is incorrect. My lady, without further ado, I am in agreement with Mr. Late and Mr. Pienaar, and I support their submissions that the application has not shown to be factually or legally founded and should be dismissed. As your ladyship pleases.
Thank you very much. It's now 21 minutes past 11. We're going to adjourn for tea, and then those who want to address the court, that will be done when we resume. Thank you very much. Court agents.
May it please the court, my lady.
Yes.
Please.
Hello, can you hear me?
You are
Can you hear
audible,
me,
my
Mara?
lady.
Yes, Ms. Toka, I see she's ready. There was Mr. Profi before you. Would you want to go before Mr. Profi? Ms. Toka?
My lady, Ms. Kotka is my senior, so may I request that she go before me, please?
Okay, that's fine. You may proceed, Ms. Toka.
You muted.
She is muted.
My apologies, my lady. My
Yes.
lady, I will only deal with two issues that were raised by Mr. Pihlela.
Yes.
The issue of recalling Dr. Mkachwa and Ms. Buthelezwa, witnesses of life Esidimeni, and the issue around the biasness of the court.
Yes.
My lady, this is not a normal matter of recalling of the witnesses. Mr. Pihlela was not present, my lady, when these witnesses testified.
Yes.
Mr. Sibara, my lady, raised an issue with us proceeding with the owners of NGOs not being represented.
Yes.
These two witnesses, my lady, I submit that they are called out of necessity. It is necessary that they come before the court, that Mr. Pihlela be given an opportunity to cross-examine them, my lady. If my memory serves me well, my lady, Mr. Pihlela is representing amongst the clients that he's representing Mrs. Karina Morale, the
Yes.
owner of Tepong, my lady. My lady, from the evidence that is before court, I can agree, my lady, that Mr. Pihlela has to have questions on behalf of Mrs. Morale posed against Dr. Mkachwa or Mrs. Buthelezi. I'll submit, my lady, that in objecting to these two witnesses being recalled in order to afford Mr. Pihlela an opportunity to cross-examine them, it does amount to us not appreciating the role that has been played so far by Mr. Pihlela. On those basis, my lady, I will submit that it is fair that those witnesses are recalled, that Mr. Pihlela is afforded an opportunity to cross-examine them, in particular on behalf of Ms. Karina Morale. On the issue of bias, my lady, I did not understand.
If you can assist me on this aspect of Ms. Morale, what is it that maybe came out of that evidence of Mr. Mkachwa and Ms. Karina Morale? Because the difficulty, okay, continue.
There is evidence.
There is, just a second, there is another hand. Who's that?
Sorry, Madam Isibara.
Okay, thank you. Please don't interrupt me. I've noted you. That's fine. Yes.
My lady, if my lady will recall, there is evidence by Miss Rochelle Gordon, the witness that I am representing, yes, where she indicated that, in her view, some of the patients that were discharged to Tepong, they were not supposed to have been discharged to an NGO, but they were supposed to have been transferred to a hospital. And then there is also reference to Franz Decker and Sina Musalo. There is a third gentleman, I just forgot the name, my lady. My witness indicated that those patients were not supposed to have been transferred to the NGO, in particular, the NGO of Ms. Karina Morale. My lady, it will assist the court if Ms. Karina Morale cross-examines, in particular, Mrs. Buthelezi.
Okay.
It will assist the court in arriving at a just decision at the end. On the issue of bias, my lady, I did not understand Mr. Pihlela to be saying the court is biased, which would necessitate an application for recusal of the court. All I understood him to be saying was to raise a concern that may lead to unnecessary misunderstanding. My lady, if an objection is raised, I support Mr. Phihlela that it should be an issue between the person who is raising an objection and a person against whose question and objection is raised. And then my lady makes a decision. That, my lady, I submit, will save a lot of time. My lady, if a practitioner does not raise an objection, it means that practitioner does not have any issues with the objection or evidence, with the evidence that has been led. On those bases, my lady, I submit that it will be fair for the witnesses of life Esidimeni to be recalled in order for Mr. Phihlela to be afforded an opportunity to cross-examine them on behalf of his clients.
Okay.
That is all, my lady. Thank you.
Thank you. Yes, Mr. Profi.
My lady, may I just get an indication if Mr. Sabara's hand was up and if he'd like to go before me?
No, but you can just go now. Mr. Sabara will come later. It's fine. He will come after you.
It's fine, my lady.
As the court pleases, my lady, Ms. Kota has taken majority of the words out of my mouth, so I just want to recalibrate to not repeat anything that she has said. In respect of the first issue, I submit that Mr. Phihlela did not make an error, because it cannot be an error that both him and I understood the court to give us an undertaking, and then yesterday, the undertaking now comes with disclaimers, and the threshold in respect of the NGOs is now increased. And the aspect of Section 11 is now up in the air and now finds relevance when it just says that we have to show substantial interest. That interest, as the court has indicated, is that the parties were not legally represented, which they are now, and thus that interest has been shown as to why we should be able to recall these witnesses. But further, my issue was with the term recalling, is that we are operating on the premise as if Mr. Phihlela and potentially myself, because I will have a dog in this fight eventually when I wish to recall witnesses. I need confirmation in respect of, am I then expected to bring an application each time when the understanding and the undertaking was, and even Mr. van Braken saying in line with the directive. Malady's directive does not say, and it was never indicated to us, that we now have to lay this foundation in order to quote unquote recall them. If we were representing them at the time, we would have cross-examined there and then, but they weren't represented and now they are. So we never had a bite at the cherry to ask them the questions we now have. Now our learned friends are saying, hang on, in spite of you not having a bite at the cherry, you must substantiate why. And we're saying our interest is that they're not represented and they are now, and we'd like that opportunity. So even in line, I submit that if we proceed in that way, it's not anti-My Lady's directive. It's merely saying that when they come, whenever they come, Mr. Phihlela and myself will then state, My Lady, my cross-examination, as we have been doing, is in respect of A, B, C, D. Thus far, no one has objected in the proceedings to when somebody has stated their facts. We begin, and if the evidence leader or anyone has an objection to the line of evidence, the relevancy, the causation, we do as we have continued been doing. But My Lady, my frustration and agreement with Mr. Phihlela is that we have to caution against the constant changing the goalposts when the NGOs want to put their story before the court. Then the threshold changes. And if we continue in that line, the court will be, in effect, silencing the NGOs, which I submit is anti the Aurea Pacteram rule, that they must be given the opportunity to present their cases and to be heard before this court, and to put these increasing thresholds and to put these new ideas every time they try to do so is incredibly prejudicial to the NGOs. So, My Lady, I cannot agree with my learned senior, Mr. Pienaar, that they suffer no prejudice. The prejudice is clear that their evidence will not be before the NPA when the NPA has to make a decision. Their version and their questions will not be before the panel to make a decision, which heavily impacts them criminally. To then say, no, it's fine, you were not implicated, we don't want to hear what you have to say, I submit is anti the Aurea Pacteram rule, which is against the the case law that the 1940s case law that Mr. Pinar has referred us to. We have changed, my lady. We've changed tremendously in terms of how the courts operate and the freedom and liberty which people have to the courts and to bring their versions before the court. My lady, in respect of the second submission, in respect of the majority rules in the panel, and I'm not putting words in Mr. Priscilla's mouth, and he can correct me at any stage if I'm wrong. I understand him, as Ms. Kota has stated, that it is a mere caution that we cannot, with respect, expect somebody that if I make an objection, and it's going to be in line with Mr. van Bruggen said that yesterday he, out of good heart, came to the assistance of the court when he didn't have to. I submit that was not the case, that it wasn't from the goodness of his heart that he wanted to assist the court. It was that if I had proved that the plastic was indeed consumed at Life Esidimeni has a direct interest in that evidence. So Mr. van Bruggen had to come to the aid of his clients. And that's Mr. Priscilla's point, that if an objection, just as an arbitrary example, if there is an objection between myself and Ms. Hasim, and we have a contention to get through, if Mr. Pinar and Mr. van Bruggen, who, if I'm correct, have an interest in that objection, will come to Advocate Hasim's aid because they are mandated to do so. So it's merely cautioning the court to be aware of that majority rule outcome. We are all here on a mandate. We're not just sitting here just for the sake of sitting here. So I submit that Mr. van Bruggen is incorrect when he says that he did it yesterday. That speaks to Mr. Priscilla's point. It happened just yesterday. So, my lady, I submit that Mr. Priscilla's, both of it is the precaution is valid, and that we should be allowed, that the process should continue as is, witnesses be called, we tell the court what we're going to give evidence to, and we proceed as we have been proceeding.
Thank you. Is that all?
That's all, my lady. Thank you for the opportunity.
Mr. Sibara?
As a please the court, my lady. I'm going to be quite brief. Advocate Profi just
Before you proceed, can I check if there is another person after Mr. Sibara? Yes, there is Sacha. And then after Sacha? Okay, continue, Mr. Sibara.
My lady, we've got
Ms. Seboko, yes, I've noted you, that's fine.
My lady, we've got system in place before you. We always object.
I can't see you, Mr. Sibara.
I'm struggling with my laptop, my lady. The camera is...
That's fine, you can proceed.
Thank you. Even my network is very bad. It's always cutting off. My lady, we've got systems in place before you. Objections are always raised when colleagues are asking irrelevant questions. We have exhausted the better morning of Friday, which Mr. Pichela could have used to ask questions to Dr. Mkacho. My lady, the NGOs are on the eyes of the storm before this inquest, including the department. And Mr. Pichela represents plus minus 5 persons before you. And if Mr. Pichela will dare and detour and take a wrong direction during cross-examination of Dr. Mkacho, the court is here. He's going to be stopped. We will stop him. I don't understand the anxiety where it is coming from.
Which anxiety now?
Now we need to dissect the grounds upon which he's recalling him. Dr. Talatala was recalled 4 times. All the parties which recalled Dr. Talatala were never requested to outline the basis of the cross-examination. Everyone cross-examined. Yesterday, my senior advocate Van Bergen was given an indulgence, irrespective of the fact that Dr. Talatala was only recalled for Advocate Pro and Mr. Pichela. He was given that opportunity. Mr. Pichela was never asked to outline the basis of recalling Dr. Talatala. Advocate Prof was never asked to outline the basis of recalling Dr. Talatala. It is not only Dr. Talatala who was recalled, my lady. A number of witnesses recalled, and this exercise was never undertaken.
Okay, I send you a message.
And if my mind serves me well, my lady, sorry, my apology to interpose you. At the time of Dr. Mkhatshwa's evidence, he testified that, amongst others, NGOs were coming to Life Esidimeni to pick and choose patients. And NGOs were not ready. I've been trying to check on the transcript. Unfortunately, my case line is failing me. If there's that evidence, again, the evidence of a plastic of a patient was transferred from Life Esidimeni, I'm quite certain that now the NGOs are represented, which this court has made an undertaking. And I was meant to believe that NGOs are going to be given the opportunity to cross-examine. Now there's an issue of a plastic which was consumed by a patient who came from Life Esidimeni to an NGO. I don't want to anticipate questions from Mr. Phihlela to Dr. Mkhatshwa. The reason why Mr. Phihlela, my lady, does not want to outline the strategy and questions which is going to put to Dr. Mkhatshwa, that is his planning. It's exactly what happened one day when my senior advocate Hasim was cross-examining. Even Advocate Pinar came to her defense that she's building up to her cross-examinations. And the questions she was putting to the witnesses then, they seem to be irrelevant. But if then Mr. Phihlela would then outline today what he's going to ask to Dr. Mkhatshwa whenever he's going to be given that opportunity, we're going to do a post-mortem of his cross-examinations before you cross-examine a particular witness. And is this court exercising out the alteram patem rule? No, we are not. And we are failing these poor NGOs, which are represented by these poor black women, which this court patiently waited for them to have a legal aid person to represent them. Now they've got legal representations. We're shutting the door on their
You should have been audible on record. You should have been properly seen so that everybody can see, you know.
Thank you, my lady. I'm quite passionate about this issue, my lady, because myself and this court, we tried our best to have Mr. Phihlela before you. Now we seem to be curtailing his progress. We seem to be blocking his way to represent these people effectively. I don't see any harm for Dr. Mkhatshwa to be cross-examined by Mr. Phihlela. We are definitely going to block him if he does and goes astray. Those are my submissions, my lady.
Thank you, Mr. Sibara. Then who's next? Sasha?
Good morning, my lady. Firstly, I hope that Nelisiwe can convey to you our apologies that our counsel is unavailable today and that I'll be stepping in.
Yes, okay.
Thank you, my lady. We just wanted to record our agreement with the submissions of Mr. Van Berg and Mr. Late and Mr. Pienaar in relation to Mr. Phihlela's application to recall the two witnesses. That's all we need to say on that. Ms. Hassam further made submissions yesterday on the same matter, and I don't think it's gone much further today. On the second matter of what's now being called Mr. Phihlela's caution, we must note that it's highly improper to make what is really an allegation and to use the words reasonable apprehension of bias in relation to a judicial officer without going through the normal process, the proper process of making an application for recusal. So we must note that we consider it to be inappropriate for that allegation to have been made, my lady. Those are all of our submissions.
Thank you very much. Please, Soko.
As a court pleases, my lady. My lady, in respect of what Mr. Phihlela has placed on record, I just want to respond to two issues. On the issue of the bias, I do not agree with Mr. Phihlela's chosen mode of highlighting that aspect. And I agree with Mr. Van Bergen that the procedure or the process followed by Mr. Phihlela is incorrect. On the first issue, which is the recalling of witness, if I may be permitted to take your ladyship way back, just before Mr. Phihlela started. Yes. We all recall Mr. Phihlela in the time that he did a lot to try and cover a reading. I remember my words to him when he was addressing the court, complaining about the time which he had to read. I said, Mr. Phihlela must bend the midnight oil like we, the latecomers, did. I want to make the submission that under the circumstances, Mr. Phihlela has done all he has. And one of my colleagues who spoke before me said undertakings were made. Yes, indeed, undertakings were made to the NGOs, to them personally, even when they did not have Mr. Phihlela representing them. I remember specifically your ladyship asking the ladies of the NGOs to attend until legal aid through the efforts at the time of Mr. Sibara appointed legal representation for them. I therefore believe it is indeed in the interest of justice that Mr. Phihlela steps in and does the work a lawyer only can do, which is cross-examining the witnesses. Mr. Phihlela has tried, and we all agree, in the time that he had, to do his best to represent these persons, and based on the undertakings which were made to the ladies, that once legal representation is done, Mr. Phihlela has been provided, Mr. Phihlela would be allowed an opportunity to cross-examine and to represent the interests of the NGOs as much as he can. My submission, therefore, is that he should be allowed to recall witnesses, my lady.
Thank you. Anybody else? Are we done? I see Mr. Van Bergen, Mr. Profi again. Oh, Mr. Pinar again. Before I go to these ones who had already addressed the court, is there any other person that I'm leaving aside before I go to those that have already addressed the court? I see this hand. Whose hand is that? Whose hand is that? Okay. There is another hand. If you can just put that hand down, unless if it's anybody who has not yet addressed the court. Okay. I'm going to go back to, I think first it was Mr. Van Bergen, followed by Mr. Profi, then Mr. Late and Mr. Pinar. Over to you, Mr. Van Bergen.
Thank you, my lady. There's just one aspect that I wish to address. It is not directly relevant to the point that your ladyship has to decide, but it pertains to me and my standing as an advocate appearing in proceedings before the judge of the High Court. And I wish to record my objection to Mr. Profi's insinuation. Well, it goes beyond an insinuation, who placed in issue what my motives were in examining Dr. Talatala yesterday. If he seeks to impugn my integrity, he must expect consequences. I may indicate, my lady, that it is not the first time that I did something of that nature. During the examination of, I can't remember the doctor's name, he was called by Ms. Foster in respect of the death of one of the deceased, of whose families she represents, where I assisted Mr. Shabangu. And that was a patient who had not been transferred from Life Esidimeni. So I would request Mr. Profi to reconsider in open court, placing a question mark over my integrity, as your ladyship pleases.
Thank you. Mr. Profi.
Mary, the intention was never to cast doubt over Mr. Van Bergen's integrity. That evidence yesterday was incredibly helpful to myself, and I presume the court, in terms of the clarity that it provided. So the question was never his integrity, because that was incredibly helpful. What I'm saying is that there is merit to Mr. Priscilla's caution. It had nothing to do with the integrity of Mr. van Bruggen at all, because now we have to bring, based on Mr. van Bruggen's evidence yesterday, we now need the pathologist to come back on the basis of that evidence. So he's always been incredibly helpful to the court. It's why he's so vocal. So I never cast question over his integrity.
Yes, as we are on this point, I just want us to be careful how do we use our words, because I understand that emotions are not going to help us. What is important is to assist the court to arrive at a proper decision. We know for a fact that this is an inquest, right? So we should just be careful how we say things on record, especially that this matter is in the public domain. Yes, I hope, Mr. Profi, you have heard Mr. van Bergen, and I take it that will therefore clear the matter.
I do extend my apologies if he thinks that my wording was inappropriate and that I caused doubt in his integrity. Okay. It was merely just an arbitrary example of Mr. Priscilla's point, but it was not bringing Mr. van Bergen's integrity into question.
Thank you very much.
My lady, while I'm on my...
Just before you proceed, I hope Mr. van Bergen, this clears the issue.
I'm satisfied that it does, my lady.
Okay, thank you very much. Mr. Profi, you may proceed.
My lady, I'm going to be very brief. The second, I omitted to address the evidence leader's submission in respect of Mr. Priscilla's timeline, or the time he brings his application that his witness is next. Okay. Again, Mr. Priscilla can speak for himself, and it's not my intention to speak for him, but I submit that I do fall in the same boat as Mr. Priscilla, that it would be offensive to me for the evidence leader to say that to me, given that we are doing, Mr. Priscilla is represented by is representing a number of people, and myself coming on for two at a very late stage, that for myself, for example, we are consulting over the weekend, we are consulting in the morning, to avoid, and I've intentionally avoided the stance of telling the court that I'm simply not ready to proceed on a witness who is coming. So we do our very best to fully prepare for whichever witness is next, and that's why he's found himself and bring the application today that his witness is next. I submit that it's very unfair to then say he's merely, whether he's trying to delay or making an excuse because his witness is next, is not the case. That we are burning the midnight oil and we're trying to avoid postponing the matter. But in balancing that act, we also have to be fair to the cases we have to present. So it's not a matter of trying to delay or be dubious the way we bring an application. But I just request the evidence leader to be mindful that the proceeding is quite intense, the amount of documentation we have to go through, and that we prepare as and when the witnesses come along. So it would be unfair to then say, even for myself, if I were to tell the court when my witnesses were to come that I'm simply not ready because I've been preparing for previous witnesses to not postpone. I don't want to then be told, Mr. Profi, you're being inappropriate by bringing this application. The timing is questionable. I submit that he must remember that our workload is heavy and we're doing the best we can.
All right, thank you very much. Who's next after that? Is it Mr. Late or Mr. Pinar?
My lady.
Yes.
I've listened to the arguments all in favor of the cross-examination by Mr. Priscilla of the witnesses, and there's one golden line that I think everybody takes that is not consistent with what we are opposed to. We are not opposed to him having the opportunity to cross-examine the witnesses. That's not, neither myself, nor Mr. Pinar, nor Mr. van Bergen said that we are opposed to his opportunity to cross-examine the witness. All we ask is that he comply with the provisions of Section 11(2) of the Inquest Act, in that he that he tell the court what his reasons for cross-examination for these witnesses are, and outline the outline his questions to these witnesses, as it is clear before this court that they had not at all been implicated by these witnesses, or his clients had not been implicated by these witnesses, and that causes a shadow over the applicability of cross-examining these witnesses, as the court pleases, my lady.
But what I pick up from what they're saying is that there was evidence that related, if you remember what Ms. Koka submissions were in relation to the issue of Sepong, Karina Morale, that those patients or deceased who went to Sepong were not supposed to go there. So that is what I picked up from Ms. Koka.
Yes, but
and
my lady, the evidence is that
just a second. The other issue, if I understand it, Mr. Pitlela will clarify at the end. The reasons that he gives is that because of the fact that he was not there at the time, right? So that is why I was saying, is he taking me back to what was to what he said yesterday before we adjourned? Because he said he was given a legitimate expectation because an undertaking was given to the court, to the NGOs in particular, their representatives, to say, attend the proceedings, and should there be necessary, when you have legal representation, you'll be afforded the opportunity. So that is the reason why he doesn't want to say anything. And if you understood Mr. Sibara is saying, why don't you allow him? Why don't the witness be recalled? And where he asks questions, and those questions, we will be in court, the court will be there to hear the questions that will be asked to these witnesses, so that those questions can be scrutinized if possible. That's how I understood the arguments.
My lady?
Just before I allow you to, Mr. Sibara, are you there? Maybe he's saving you. Okay, let's continue then. Yes.
As far as Tsipong is concerned, the evidence throughout was that Life Esidimeni and its employers were not involved in the placement of the mental health care users. The decision where the mental health care users were taken was taken by the Department of Health. None of the two witnesses had anything to do with the placement of the mental health care users. So that is the reason why I say none of the NGOs were implicated or involved in the actions by the two witnesses. As far as Mr. Sibara is concerned, or let me first deal with Mr. Pihlela's reasonable got now the word. He is a legally qualified person. He knows the act. He deals with an inquest, and if anybody is involved in an inquest as a legal representative, you should be conversant with all the sections of that act. I now refer to the And as far as Mr. Sabora is concerned, we must take into consideration the interests of the two witnesses also. I can't see I can't see any reason for Mr. Phihlela not to just to outline the connection of his clients and these witnesses and the reason why he wants to recall the witnesses. How difficult can that be? We're not asking him to give all the legal representatives the questions that he wants, the specific questions that he wants to ask them. We just want him to indicate to us how these two witnesses entertain or is entertained by the NGOs. How can they at all ask questions regarding his witnesses or his clients? That's all we ask. And if he can indicate to the court sufficiently that there is a direct link between his clients and the two witnesses, and that is why we want to ask certain questions. Why don't he do it? Why doesn't he do it? It's easy. It's not difficult just to provide the court with the outline of the reasons why he wants to cross-examine them. It doesn't give away anything to this court in any way. This court is not a criminal a trial court. It's an inquest court, and this court is doing the investigation into the deaths. We are not playing hide and seek, like Mr. Pina has indicated to the court. It's not a game that we are playing. We must assist each other, and we must also to the interests of the witnesses as well as the clients and the family of the deceased. That's the court, please, my lady.
Thank you. Mr. Pinar.
May it please the court, my lady. My lady, I trust I will not be beaten for brevity this time round. But, my lady, just a few simple matters or issues that I'd like to address. Firstly, the first issue is the fact that Ms. Murale from Tsepong NGO, having received patients from Life Esidimeni, it must be kept in mind that both Dr. Makachwa and Ms. Buthelezi reiterated and confirmed that they were not involved with the selecting and placement of mental health care users to Tsepong, for example, which was specifically put to them when they were under cross-examination. So therefore, my lady, what is of importance is relevance. And once further cross-exam, now the fact is at this stage, my lady, the evidence that has been elicited from Dr. Makachwa and Ms. Buthelezi when they were under cross-examination means the evidence that they presented was accepted, my lady. If any of the parties denied that or had evidence to the contrary, surely it should have been put at the time they were under cross-examination. Now I realize Mr. Phihlela was not in that position at that time. Yes. But my lady, now the fact of relevance becomes of importance because the answers, the evidence that had been presented is now collateral evidence where the answers obtained are conclusive. So, and I think the error that's been made, my lady, by my learned friends in a certain sense, and now I'm referring to Mr. Sibara with respect and Mr. Profi with respect, is not that when an application is launched to have a witness recalled, that the specifics and the detail should be disclosed. The crux of the issue is what needs to be disclosed is the relevancy and the crux of the relevancy for the need to recall. So that is the crucial issue, and that's the principle that's involved, my lady. And for Mr. Profi, with all due respect, which I found a bit, or the innuendo that I must keep in mind, times have changed. My lady, I think I'm well aware.
Mr. Boko, I've noted you.
The fact remains, my lady, principles have not changed. The applicable principles in law has not changed. And for that reason, my lady, if called upon, although I referred to a decision of Rex, the decision of Rex versus Zaki 19 in the 50s, my lady, I can carry that principle further back, and we will find it already in the South African law reports in the old Cape Digest of 1850, more than 200 years ago, my lady. But the fact is, we must not lose sight of principles. So we must not allow our subjective sentiments to cloud our vision, my lady. With all due respect, what the principle is, application must be proper and founded. It does not require specifics of the questions to be asked in detail. That would be an improper and unjust requirement, my lady. And that's not the requirement. But at least there must be the requirement that's of utmost importance and prime importance is there must be relevancy in recalling a witness. And that means not detailing the questions and the answers expected for that matter, but a broad outline of why it may be necessary, taking into consideration the evidence that has already been adduced by the said witnesses when they were under cross-examination by certain of our colleagues at that particular stage, my lady. And the nature of that cross-examination, we must determine, at least in an application of this nature, the relevancy of the need to recall must be set forth. Otherwise, it means an application to recall becomes a mere formality, which is not the principle applicable in law as today, my lady, and it will be applicable. It's for the future also, and it's straight law, my lady. It's straight with regard to the rules of evidence and the applicability in the law of evidence when there's an application to recall a witness. Not only in terms of the Criminal Procedure Act and the sections I've referred your ladyship to, or Section 8 of the Inquest Act, my lady, but also in terms of the common law, it is applicable, my lady. And
thank you.
That's all that's the crux, relevancy, my lady. Otherwise, it's, as I've indicated, we're bound to the answers that have already been elicited under cross-examination because it becomes a collateral issue, as the court pleases, my lady.
Thank you very much. Mr. Boko.
As the court pleases, my lady. My lady, I'm going to...
Now you are sending the right way. Is it Sebo? You know, I always, is it Seboko? Because Seboko, the meaning of it to me, that's why I keep on.
That's the one.
Okay, Seboko, then I'll be used to it. Continue.
My lady, I apologize that I have to ask for a second bite of the cherry, but I think in line with what Mr. Late addressed your ladyship, I just need to make a contribution. Mr. Late, and correctly so, he always reinforces the issue of relevance in cross-examination. And I think, although he is correct to keep on reminding us that nobody is on trial here, what your ladyship is busy interrogating is the cause of the death or the mechanisms of those deaths. Indeed, your ladyship is concerned with establishing who the deceased is, when, where, why, and how those deaths occurred. If I juxtapose that address by Mr. Late against the request of Mr. Phihlela, it is clear from the evidence we've had so far, and especially the evidence of Talatala previously, but in particular of yesterday, that where the NGOs are concerned, patient management seems to be the issue at stake. And that patient management dent is also attached to the witnesses or some of the witnesses presented by Mr. Phihlela. I want to go back to Mr. Late's words of causation. Where there is should there be a possibility that those represented by Mr. Phihlela might have done acts of negligence, or there may be parts of negligence where they are concerned regarding the healthcare of those people that are expected. Surely this is something that Mr. Phihlela needs to deal with. Yes, causation is what your ladyship is looking at, but that doesn't mean negligence does not play a part or is not important or pivotal in issues of an inquest. If that evidence sought by Mr. Phihlela, yes, we all don't know what Mr. Phihlela seeks to elicit at this point until his request to recall is allowed. The bottom line is this. If that evidence is not elicited, it means the next fallback evidence which your ladyship must now rely on to establish, be it causa or be it negligence by those who were managing the patients at these NGOs. Your ladyship will now have to rely on forensic pathologist evidence who had performed those autopsies, right? And I think it was through the evidence of I'm not certain now, but Advocate Hassim SC kept on referring to the autopsies. It is important, my lady, I want to submit that the evidence Mr. Phihlela will or may elicit, should he be recalled, permitted to recall. And I'm saying this very aware of the words of Mr. Late. When he says he's not denying Mr. Phihlela the opportunity to recall, he is just warning that recall or the evidence must remain in the bounds of what we have already established, and maybe even, if I may put it higher, and say set as a standard, which is the relevance of the cross-examination which we as the legal representative will elicit. And I think all of us have been able to some extent, a large extent, to toe the line where that is concerned. So honestly, I just needed to bring in the issue of negligence is also not to be entirely excluded. The caregivers have been accused, or there's evidence of a deceased, unfortunately, chewing on inedible. I think Dr. Talatala's word yesterday was inedible. It is therefore imperative that we recall, and in light of what I've said, I think I'm going back to the issue of should we not toe the line for Mr. Phihlela to say, give us set out for us what questions you need to ask the questions in light of the evidence of Dr. Daladala yesterday, where he has impugned the conduct of some of, and I might be using a strong word, and I apologize to Advocate Hasim and the representatives of Dr. Daladala, should I be understood that way. But I use the word impugned for lack of a better word. He has impugned the conduct of some patient management facilities to say, how does, for an example, somebody eat anything or swallow anything inedible in your care? And I really am saying this to support the application, the first application by Mr. Phihlela.
Okay. But as just before you step down, Ms. Siboko.
Yes, my lady.
Are you saying this evidence can assist if the court allows them to come and testify for further cross-examination? Are you saying that these issues are going to be cleared also? But
correct,
what is it that they're going to say? Because already on record, we know that this patient, before he went to this NGO, he was at Life Esidimeni.
Marlene, I think that's
because the way why I'm saying this, the way I understand the premise from where Mr. Late comes from. Mr. Late is submitting that they are not necessarily denying Mr. Phihlela the opportunity to cross-examine these witnesses. All what they are saying is that he must at least lay a foundation to say, I will be dealing with 1, 2, 3, not necessarily to disclose the questions to this court.
I agree with that one.
As I did yesterday, because I had expected him to come and say, this is how my line of questioning is going to be done, full stop. But so far, we don't know what is it that he's going to say to us, right? If I understand his argument, but well, he will reply. If I understand his argument, he's just saying on the basis that there was an undertaking, which argument you also supported, to say there was an undertaking by the court to my clients, right? That as soon as they get legal representation, they will be afforded, that legal representation will be afforded the opportunity to cross-examine the witnesses that had already testified, right?
Yeah.
And if one may distinguish this, the evidence of the 2 witnesses that Mr. Phihlela wants to recall, and the witnesses that have already been recalled, can't we say there is, in fact, a huge difference? Because like the evidence of Dr. Talatala, there was nothing wrong with that evidence because a lot has been said regarding the NGOs. And it was in particular relating to the care, isn't it?
Correct, Malene.
Now, the way I understood this argument by Mr. Late is that insofar as the evidence of the 2 Life Esidimeni witnesses, they testified about incidents prior to the transfer of the patients. That's how I understand it. Maybe you can just try to assist me in this regard.
My lady, I understand the evidence, leader, exactly how my lady, your ladyship understands the evidence, leader. You are called upon to testimony from all sides, and when it comes to the issue of Mr. Phihlela setting out the topics which he needs to cover in cross-examination, I agree that yes, he should be afforded, before he is even recalled. But to say, not to say which questions are you going to ask. And previously, I've watched, and we all agree that your ladyship has been able to give objective rulings where some of us are stepping outside of the line and they agreed. However, in this case, if I may, if without sound, at the risk at sounding as though I'm prejudging the issues.
Yes.
When I personally, from where I'm sitting, listening to the evidence of both Life Esidimeni and the witnesses who are the NGO members. The issue which I pick up for myself is that the conduct of both Life Esidimeni and the NGOs with respect to both the diagnosis and treatment, and I say diagnosis, very aware of the evidence before you, that there's still a dispute about who had, whether Life Esidimeni released documents to the NGOs or did not release the document. The evidence of Ms. Mukhosinyane when it comes to medical diagnosis and treatment of the patients is still fresh in our minds because she finished this week only. That evidence of the medical diagnosis, the medical documents and treatment should be tested against the standard of either a reasonable doctor or a reasonable patient management facility. Now, on the issue of...
Just a second, I think Mr. Late is now, he's joining. Yes, continue. I don't know whether he's there yet. Mr. Late, are you there?
My lady, I'm here. I was kicked out. I just
yes, I saw that. Again. That's why I stopped, Ms. Seboko. Continue, Ms. Seboko.
Yes, my lady. Just to say in conclusion, those forensic pathologists who have performed those autopsies with the possibility of negligence on the part of anyone, of any of the witnesses, whether or not those witnesses are on the witness list, will be needed and expected to determine the cause of death in line with the review of the hospital records and the statement from every witness concerning the treatment, and recommend whether or not a finding should be made or the causa as Mr. Late speaks about. And the negligence aspect, I don't think it's something that your ladyship will have to, it's something that your ladyship may also have to consider in the final analysis. So if Mr. Late was not here when I said I agree with him to say Mr. Phihlela should give us an outline of the aspects he wants to cover without expecting him to tell us his questions verbatim of what he's going to ask.
Okay, thank you.
Please.
Who is next before I go to Mr. Phihlela? Is there any other person? Mr. Phihlela, are you ready to reply?
Scott, please, my lady. Oh. My lady, before I start on my answers, on my reply, there's just one aspect that I would like this court to, and it's something that is very heavy on my heart, because in as much as nobody likes the integrity to be impeached, they should not go about trying to impeach other people's integrity. Utterances that were made by Advocate Late to the effect that I've got an ulterior motive by bringing this application, which are unsubstantiated, my lady. I supposed to be very objectionable because I've described the reasons why, and also to question the timing of the application. At the end of the day, my lady, we deal with these matters as they arise. Now, your ladyship has indicated before that we need to finish with all those witnesses who are hanging. And that is the motivation that brought me to this conclusion to make this application, my lady. Mindful of the fact that those witnesses, whatever they may come and say, I cannot deal with Ms. Dorothy Franks before we have disposed of all those witnesses. And that is the reason. And also, Advocate Van Bergen SC, I mean, my lady, when he says that I'm trying to intimidate the court, I don't understand what that means. Because I'm an officer of the court. Why would I go to so much trouble to try and intimidate this honorable court? I think it's a way of impeaching my integrity, my lady. Because in as much as his integrity should be respected, he should respect the integrity of others. I've got no ulterior motive in bringing this application. I indicated from the start, my lady, that I felt a duty to bring certain things to the attention of the court. Now, the court, if the court doesn't, the court has an election whether to take those into consideration or not. Advice is freely given, my lady. And that is the basis upon which I was merely pointing out to your ladyship that these things, they create a negative perception. Your ladyship has correctly pointed out that these processes are carried out in public. And anyone who bothers to go on YouTube and see and listen to the comments that are being made will understand from where I was coming from. And not immediately assume that I'm bringing this thing because I've got an ulterior motive of whatever nature that is. I take exception to that. And whoever doesn't respect my integrity, I will not respect theirs. My lady, if I may deal with the submission.
Before you go there, if I may, I don't want this type of language to be used in this court. Mr. Verken, do you want to say something with regard to this so that we can lay to rest?
Thank you, my lady. My lady, I did not impugn Mr. Pishlela's integrity. I stated as a fact what is law and practice in our courts when it comes to applications for recusal or suggestions of bias on the part of judges. And I stand by what I said, my lady.
I'm just going to ask that we must just be mindful of the fact that we are in the public domain and this is a courtroom. We must just have to control our emotions and try to be here as officers of the court so that the proceedings in court can be done in a proper form. Continue, Mr. Pitlela.
No, thank you for that reply, my lady. From Advocate Van Barkhan SC. My lady, I'm going to deal with, firstly, I want to clarify something that I feel is being missed.
Yes.
My stance with regard to the application for the witness who was reserved and whose undertaking was given to be, will come back to the proceedings. I'm loath to use the word recall because the recalling presupposes different things. The context in which we are applying it in this matter, we are not in the strict sense of the word recalling that witness.
Just a second. I don't know. I think it's from your side. Continue.
The witness is not being recalled. The cross-examination, the effect of that undertaking is that the cross-examination of this witness is postponed or suspended until a future date, should the need for that cross-examination arise. My lady, I've also indicated to the Honorable Court that my stance is not that I cannot give an indication to this court why I want that witness to be recalled. I have indicated that my only reservation is to do that because in order for me to explain thoroughly to this court why I need those witnesses recalled, I will have to disclose where I want to take them in terms of their cross-examination.
Which is not what we want you to do. You are not compelled to do that. All what they're saying is that at least you should just indicate as to why you want these witnesses to come back and for further cross-examination. Whatever you call it, whether it's a recall or it's a reservation, that's all what they're saying.
My lady, and I understand. Now, the other issue which can
you pass this one first? If you can just pass this one first and then I don't want, because I'm raising this with you, yes.
My lady, the two issues are related because
okay, all right, but you should come back to this one if you don't come you don't deal with it now. Yes.
Yes, my lady. The two issues are related because when we look at how we have applied the directive, it has been that when a witness is on the stand, whoever wants to cross-examine will then stand up and indicate to the court, these are the aspects that I'm going to deal with. and then proceed. And that is how we have applied it. But now what we are trying to do is
a witness who has already been called, who's now before court.
Correct, my lady.
Yes, now we're talking about a witness who has already testified. Now you want that witness to come for further cross-examination.
My lady,
no, I'm just saying you can continue, that's fine.
That is my point of departure.
Okay.
Because if we look at it as, I wasn't present when that witness was testifying. The court was prompted to give that undertaking, recognizing that an injustice might otherwise be done if an opportunity is not granted for me, if I'm the legal representative, to cross-examine those witnesses, my lady. I have not had it. I'm not taking a second bite at the cherry. I have not cross-examined. And that is what is distinguishing in this matter. Because we are now dealing with two aspects instead of one. The directive dealt with only one aspect. And that is, you need to indicate to us where you're going with your cross-examination at least, so we know in advance whether for the court to make a determination in terms of section 11.2. But now we have extended that, and we are laboriously extending the realms of section 11.2, because now what we are saying is, before we even call that witness to come and testify, we need you to tell us why you want that witness in particular to come and testify. And the only reason why we want to know is because the witness has already testified. And we feel that the witness has testified sufficiently. And therefore, we don't see any value that your testimony is going to add or your cross-examination is going to add. And that is
let's not put words into other people's mouth. What comes up from the submissions, in particular, Mr. Late and the others, they are saying the witnesses, these two witnesses, gave evidence which pertain to issues that happened prior to the transfer of the patients to the different NGOs. So that evidence, according to them, does not implicate any of the NGOs. That is what they're saying. Then you can take it from there. That's how I understood the arguments.
My lady. I think Advocate Suboko has taken the court through that process.
Yes.
We cannot speak of only issues that are narrow in this inquest. During the cross-examination of Advocate Adila Hassan SC, she put a proposition to Ms. Mokosinyane that because of a certain number of deaths that occurred, that is an issue. And that the witness should be shocked or whatever the case might be. Now, this line of cross-examination was allowed. So we cannot now come and say, in one instance, we were able to pursue this line of cross-examination, which has no bearing, if one might say so, on whether or not causation or who died and how they died and this and that, my lady. But it was allowed. Now, I will place it on record, my lady, that what I want to deal with those witnesses has to do with the consultations that I had with my clients in respect of the testimony that those witnesses gave. Now, I'm not at liberty to disclose those consultations due to the attorney and client privilege. I can only put those questions to that witness when the witness has taken the stand. And before the witness after the witness has taken the stand, I will explain in detail to this honorable court, as required by the directive, to say, these are the issues that I am going to advance with this witness. The witnesses are well protected. Should an issue of relevancy arise, it will then be dealt with at that stage. It is not for me to convince this court of the relevancy of a cross-examination before I have cross-examined. And that is not what the provisions of 11.2 contemplates, my lady, I humbly submit in that regard. 11.2 does not contemplate that. Does not contemplate that the court is going to, in advance of questions being asked. It says the court will decide whether to allow a question or not. And that is a question that has been posed to a witness who is taking the stand. The court is still in control of the proceedings. The court can still make determinations with regard to relevancy. But at that stage, now the precedence that is being created by this is going to be problematic, my lady. And it's going to serve only to limit the progress of these proceedings. Again, I'm not trying to intimidate the court, my lady. I'm merely expressing my fears and concerns.
Did you answer the, I don't know whether you still have further submissions to make?
Yes, I just wanted to clarify a few things with regard to what has been said before, my lady. The issue of a substantive application, my lady. My lady, I know how to bring an application for a recusal, and I know the grounds that I need to advance for an application for a recusal. It's elementary. It's elementary. I stood up and I explained before I stood up that I'm duty bound as an officer of the court to bring this concern. It's a concern that I'm airing to this court. When I indicated a reasonable apprehension of bias, I indicated that I'll group them under this heading. And that was for ease of reference. Like what a heading serves, it's for ease of reference. It is not the content of what I've been saying. And to hear everybody going on about I'm doing this, I'm doing that. And this was for the benefit of your ladyship. If your ladyship accepts that I might be correct because of the wrong impression that might prevail, especially in the public domain, that this court only listens to certain people and doesn't listen to certain people. And the one thing, my lady, that concerned me the most as an officer of this court was for the mere possibility of collusion, my lady. Because that indirectly will influence whatever decisions that this court makes. If a group of people decide we are going to bunch together and we are going to follow this, whatever ulterior motive that they might have, indirectly it influences this honorable court. And Mina, I just wanted this honorable court to look into those concerns in the interest of preserving the integrity and the purity of these proceedings, not for any other purpose. If I felt the need to bring an application for a recusal, I'll do that, my lady. And I've never said that is the case. My lady, the other issues, I think I agree with the submissions that were made in favor of the application that it is only fair, my lady. And the issue of prejudice is self-evident. There is no need for me to address it because I understood that one understands that if you are denied a right to cross-examine, that goes against the guarantees of Section 35(3) of the Constitution, the right to a fair trial. And everybody here is a legal practitioner. They know what the section provides. And within the right to a fair trial is the right to cross-examine, my lady. And lastly, my lady, this court, if it denies me the opportunity to cross-examine, it's actually denying itself the opportunity to hear what evidence might be elicited from that cross-examination. But the principal stance that I will take, my lady, is that it is not necessary in terms of Section 11.2 that I should first have to bring an application, a substantive application perhaps, to have a witness recalled, and then have to explain to the gallery why I need. My stance has always been, and my submission is, that is between me and the honorable, your ladyship. It has nothing to do with the others. And your ladyship should be able to consider that application in chambers. If it were possible, I would have brought the application in chambers. But unfortunately, we are dealing with technology.
What is your authority for that?
My lady, my authority is the wording of Section 11.2 and the wording of Section 8, where it refers to a judicial officer. And even the definition that I referred to with regard to what is a judicial officer. Because it does not it does not contemplate an application that should be brought in open court. That would be my submission, and that
But
is
the proceedings are in an
interpretation.
open court. Why do you want to go to chambers before the judicial officer alone? The proceedings are in open court.
My lady, my
Are you
understanding,
suggesting that you can do that in front of a judicial officer in chambers while the proceedings are in open court? How does that happen, Mr. Pichela?
my lady, all I'm saying is, in line with the interpretation, my understanding of the matter is, this application that I'm bringing, I brought it to the attention of the court that I wish to bring an application to recall certain witnesses. Now, the court now wanted to know in what respect. In fact, not even the court. I mean, those that came in opposition of that application, they wanted me to elaborate on why I want those witnesses to be recalled. I think Advocate Martins has even referred to it as a fishing expedition. And I'm saying, my lady, that it would be procedurally irregular for this matter to be entertained in open court and to have this process then dissected. And now I'll have to justify based on whatever objections have been brought by the others. Like, for instance, where Advocate Late says, we need you to tell us the questions that you want to pose. And now I'll have to oppose that and say, no, that is not what I'm going to do. And that, my lady, I'm saying, it's the duty of the presiding officer to do that, to interrogate that question, not for the duty of all the others to then interrogate the question on behalf of the court. And that is the point on which I was objecting to addressing the court in open with regard to those points. But if your ladyship feels that I need to address the issue, I can address the issue to your ladyship for your ladyship's consideration. Not in open court, because then that is going to create a problematic precedent.
Okay.
May it please you, my lady.
Anything else?
I think with regard to the other things, my lady, which are not strictly relevant to the application, I'm just not going to entertain them. I think the court now, I believe your ladyship understands my reasons for sounding that caution. And I ask your ladyship to consider them with the intention and with the intent that it was given. There is no ulterior motive there. I'm not trying to intimidate. I merely felt duty bound, my lady, to come forward and give the court an understanding of the thought process that is going out there. And I believe your ladyship can decide whether to consider that or not to consider that. But for it to be extended beyond that, my lady, is not what I have intended.
Okay.
My lady, I think those will be my submissions, that it will be unfair and for me to have to address this issue in open court. The reasons in particular, precise reasons, I can address them with the court. I don't have an issue with that. And I never refuse to do that. I merely ask that I be allowed to address them with the court so the court can make a determination in terms of Section 11.2, whether those reasons would be relevant in the bigger scheme of things. Because now it says that we are now moving into interrogatories where I'm giving questions and then the witness can simply provide an answer under oath, and then there's no need to call that witness.
Okay.
That is my humble submission, my lady.
Thank you, Mr. Pichela. I see it's 1 minute to 1 o'clock. I'm not going to detain you. What I'll do, I'll give the ruling on Monday morning before when we start with the proceedings. The proceedings are therefore adjourned until Monday. What is Monday's date?
It is the 23rd, my lady.
Yes.
My lady, if I may address your ladyship on that, I was going to approach your ladyship. I have to be in the SCA on Monday. Will your ladyship excuse me from attendance on Monday?
Okay.
I'm indebted to your ladyship.
Thank you.
My lady, there's a hand from, I think, Advocate Profit.
Did I? Yes, Mr. Profit.
My lady, just briefly too, may I be excused from Monday's proceedings? And in light of my lady giving...
Is there someone standing in for you?
The attorney should be standing in.
Mr. Van Bergen, that his attorney is always there. Yes, your attorney is always there. No?
The attorney that somebody stand in. My lady, may I just ask, in light of my lady giving an order, the order on Monday, is there no witness on Monday?
Yes, it means I'll just give a ruling, then we'll know that will pave the way forward.
Forward. Thank you, my lady.
Okay.
My lady, if I may just clarify with your ladyship's leave,
yes.
My instructing attorney in this matter, Mr. Rick Martin, is also involved in the SCA hearing. So
also, you don't have anybody.
We will arrange for somebody to sit in our absence, my lady, as your ladyship pleases.
Thank you. I see there is another hand. Mr. Profi, if you can just put your hand down. Okay. Thank you very much. The proceedings are adjourned until Monday.
May please the court.
May please the court, my lady.
As the court, please, my lady.
As the court.